let's start. Good evening to everyone, to the last panel in your experience for this year at the CPDP. And this panel is the last one, and in this sense is a bridge towards the future, because it's a challenging topic that is imagining a post-GDPR order. So after 3 days discussing about the GDPR, now we try to discuss the future order. So what is behind the GDPR? And this is the framework, more or less, of the other Lovelace Institute new initiatives that focus on this idea that we had to start to discuss what will happen in the future, where, from this perspective, the future is not tomorrow, but is a broader perspective in the next, we can say, 20 years. And this is related, of course, to the ongoing debate on artificial intelligence and more in general to the new technologies that are changing the technical scenario and the social technical scenario, and as a consequence should be have to take into account from the regulatory perspective. In this sense, this idea to discuss about a post-GDPR order doesn't mean that the order, although I don't like too much the terms order, of the GDPR is something that is not positive. Of course, the GDPR is an important step forward in the regulation of data protection, but as all the regulatory framework should be necessarily updated in the future to address the future challenges. And also in the discussion during these days, we have seen there are some challenges that are partially addressed by the GDPR. And the ongoing discussion in the Council of Europe and European Union on the new regulation of artificial intelligence focus also on this kind of limitation that affect the regulatory framework. And so in this sense, we want to address in this panel that is the first initiative of this broader project of investigation. We want to address some different perspectives about this future order, so address different challenges area in which the existing framework can be partially adequate, should be reconsidered, and so on. In this sense, the panel today is only the starting point of this analysis, this research that will be carried out in the future rounds. And for this reason, we are not able to provide you a solution, but only to provide the background for this research. It means to discuss which kind of challenges we have to address in this perspective. And without adding further words, because of course we have a very interesting debate, and also it's the last section, as I already mentioned. I want to introduce the speaker of this panel. And sorry, I have to find the place. Okay. And so from thank you. So from my right, we have Ravi Naik, and he has an experience as a solicitor in UK with a very specific focus on human rights. Then we have Orla Lynskey. She is professor at London School of Economics, and she has an extensive experience in competition law and also in data protection law, and you have also seen her in the discussion of the Julie Cohen book yesterday. And on my left, we have Amba from Artificial Intelligence Now AI Now Institute in US. She has an experience in human rights again, and she has also a broader perspective in her interest that involve not only the European and US area, but also the Asian context. And on the left, we also Carly Kant. She is the the head of this initiative, we can say, at the Lovelace Institute, and she has a background in human rights. So if you look at the profile and you find online more details about the profiles of our speakers, you can see that the sort of fil rouge is this connection with the human rights and the analysis of the impact on the technology on society and individual rights. And so I think that the first part of this panel, we should focus on this kind of issues, and so which is the potential impact of the technology on individual rights, not only individual per se, but also groups and collective entities or collective group of people, okay? And so I give the floor to the first speaker for a sort of introduction, if you can say, about the main challenge that in concrete case we have in our experience already. Thank you.
Sounds great. Thank you very much for your introduction, Alessandro, and thank you all for coming. My name is Ravi Naik. I'm a solicitor in the UK for a new law firm called AWO Legal. Please look out for us. And by way of background, I am a human rights lawyer with a very specialised practice in data rights. But before considering post-GDPR issues, I want to take some time to reflect on the practice that we have to date and where we are, because the GDPR really is in its infancy, and we're quite light on case law, and there's promises of much more to follow. As we all probably in the room know, the GDPR built on and evolved decades of data protection regulations to address some of the challenges posed by modern technology. And the GDPR seeks to give effect to the conception of data rights as human rights, with the first recital of the GDPR stating, and I quote, "The protection of natural persons in relation to the processing of personal data is a fundamental right." And by providing rights against the asymmetry of power over data in our modern economy, data rights do act as human rights in practice. We have a constitutionality of rights over technology on a horizontal footing, which moves our traditional conception of human rights from a state and the citizens. We have a vertical footing. And that's quite transformative because it provides a framework to hold technology to account. And in practice, we are able to use that framework to recalibrate the power of modern technology. And I just want to talk quickly about two cases in practice and how the unique features of that data protection regime were used to implement change. Notably, as many of you probably know, I act for Professor David Carroll in his ongoing fight for accountability against Cambridge Analytica. And one aspect of that case that's is little explored is the jurisdictional reach of that case. Because David Carroll was based in the United States, in New York, while the company, Cambridge Analytica and its parent companies, were based in the UK. Therefore, their initial defense was that our client, David Carroll, was not entitled to the protection of the data protection regime because he was based in the US. Accordingly, they told the Information Commissioner's Office, and this is a quote, that David was no more entitled to his data than, quote, a member of the Taliban sitting in a cave in the remotest corner of Afghanistan, which was a beautiful way of encapsulating how they got the law wrong. So the ICO unsurprisingly disagreed and sided with our jurisdictional arguments, that the jurisdiction of the data protection regime is tied to the sovereignty of data processing rather than to territory. And that reach has increased under Article 3 of the GDPR, and it's something to look out for. And secondly, the transparency principles of the GDPR have allowed us to bring cases about systemic and widespread breaches. Notably, we act for the leading regulatory complaint against the ad tech industry, and there's a debate going on right now in the main room about that. And it's subject to much discussion throughout today, so I won't address the details in full. But however, it's important to keep in mind that complaints were able to address systemic faults within the industry, rather than just breaches on the individual level. And whilst the regulators have maybe moved a little slower than we would like, the fact of the complaints and the small steps that the regulators have taken has led to change in the industry, which is transformative. The GDPR is therefore a great foundation from which to build out from, and how we build and develop such a regulation to complement the GDPR is what we'll be discussing today. And I just want to lay out three issues that I see in my work, which I hope may be useful provocations and thoughts for our discussion today from a practitioner's perspective. So firstly, I just want to explain the realities of access to justice in this space, whether from the GDPR or for any developing law. And as a primary point, litigation costs. When taking precedent-setting litigation, strategic litigation, there's always a risk of loss involved. And individuals and civil society groups simply cannot afford to take those risks. There's an inequality of arms issue at play, with those that control vast data sets tending to have massive resources, perversely often because they have those huge data sets. And the inequality of resources only adds to that risk for those seeking and thinking about litigation. In turn, there's an enforcement gap, which leads to an accountability deficit. And even in the most egregious cases, enforcement is often lacking. This is often compounded by the lack of action being taken by regulators, often because of budgetary constraints. Indeed, the Data Protection Commissioner, effectively the main regulator of big tech in Europe, has recently been granted about a third of the budget they requested, which is really problematic. And the amount they received is actually similar to the Irish Greyhound Board. To be clear, I have nothing against greyhounds. I, in fact, have a rescue greyhound of my own, and if I'd made slides, there would have been pictures of him right now, but I thought it'd save you from his face. I also didn't get informed consent for him. So. But anyway, the task of regulating the entire big tech industry probably requires a bit more by way of financial muscle. And this may go some way to explaining why the DPC has handed out a grand total of 0 fines since the GDPR came into force. But the lack of enforcement also prevents us being able to test the capabilities of the law. For example, while we probably all know about fines that can be issued under the GDPR, there are more creative remedies that can be brought. Being rights-based, the data protection regime provides for compliance orders. You can seek a court to order a data controller to do or not do something. That could be quite far-reaching and can have quite far-reaching consequences. You think about most companies might be able to bear the brunt of a financial fine, but being told to stop processing in a particular way may disrupt an entire business model. And think about that, for example, in the behavioral advertising space. Nevertheless, the lack of enforcement is something for us to think about if we think about future litigation and the litmus test for any future legislation. Secondly, there are constraints inherent in the data protection regime. The data protection regime is limited to relations between data subjects and data controllers, and companies take slightly strange steps of self-appointing who a controller may be, and that might not always be true. But further, what happens where there's no readily identifiable controller? And this is not an abstract notion. I'm faced with this legal facade often in my cases. Indeed, in one high-profile case, in the Google Spain case, Google argued that search is an automated decision-making tool over which they had no control. The European Court of Justice considered otherwise. They said search was to Google as Dr. Frankenstein was to the monster, and they were liable for the results. But unlike Dr. Frankenstein, there's not just one monster here, there's multiple creations, and there's ever-increasing creations of increasing sophistication and ability. So how we regulate that kind of space is going to be really important moving forward. And finally, the lack of international harmonization of these laws. Coupled with global data flows, it may result in data laundering and cyber offshoring, where companies just understand they can go offshore to different jurisdictions with lesser protections. They can escape scrutiny. The European Court of Justice has tried to remedy that with recent rulings, but they're quite limited, and how they actually work in practice is going to be really interesting, particularly where sovereign questions collide, the First Amendment in the US versus what's happening in data protection in Europe. So where do we go from here? The human rights framework provides some solutions in the GDPR, as we've seen, but its efficacy is yet to be fully tested. The challenge before us is to develop and shape a holistic regime with rights, meaningful transparency, international harmonization, and effective enforcement at its core. And while we think this might be daunting, we've dealt with it before. You think about the international legal framework that was developed to what was be called a gentle civilizer of nations, and I look forward to discussing how the law can develop to be a gentle civilizer of technology. Thank you.
Thank you. Thank you, Ravi, for your analysis of these different points about the limitation that potentially affect the GDPR. I have some comments, but I think that for the round after the presentation.
Great.
And so we move from this perspective that is based on the concrete implementation and related issues to the perspective of the competition that also in terms of concrete cases, an increasing topic of overlapping and also difficulties in enforcement, because data protection structure has its specific order in terms of authorities and also in terms of theoretical framework, and competition has another order and another theoretical framework. So it's very interesting the connection that is emerging in many cases now due to the fact that data are used, of course, to produce wealth for some big companies at the end.
Thanks, Alessandro. So I guess just in order to start, I would say that, like Ravi, in looking at this topic, so imagining a post-GDPR order, I would start by saying that I believe the GDPR is, in some senses, absolutely fit for purpose. It is a fantastic starting point that has come about as a lot of hard work over many years to get to a point where we have a very appropriate and internationally endorsed core of substantive principles, which is now backed up with more significant prospects for strong and robust enforcement. So I think that has to be the starting point, that the GDPR is an indispensable building block in a bigger overall structure. And so for me, I see this project as thinking about what the overall complements to the GDPR would look like. And so here, as I said, one big step will be kind of bringing about robust enforcement, but another is maybe to kind of zoom out from the GDPR and to look at this from a more networked perspective, as we were discussing yesterday afternoon in the context of Julie Cohen's book. So to see GDPR as one part of an overall regulatory puzzle, and to step back and look at who are the major actors that are involved in the harvesting and the processing of personal data, and what are the key relationships that are at stake there. So over the past few years in my research, I've been looking at the role of what I would say are strategically significant actors in the data processing landscape, and considering how we might impose additional responsibilities on those actors, given that any action that they take in this landscape is likely to have a far more significant impact on the effectiveness of the rights of individuals than the actions of smaller actors. And so basically what I want to do today is to kind of map a few ways in which I think we could impose additional responsibilities on those actors. And so as a starting point, I think, first of all, there are potentially two ways within the GDPR, and probably more, but two I'll talk about now, where this could happen. So the first is, I guess, if we start with the concept of strategic enforcement. So we've just heard from Ravi that data protection authorities are struggling with limited resources and with a huge influx of interest and complaints around personal data protection. Well, one challenge for those authorities is that in some member states, it's not possible for them to adopt any form of selective enforcement. So to prioritize enforcement, for instance, against big companies over small companies, because that might be looked at as discriminatory regulation. And so I've done some qualitative research on this that will be published in May, but it's clear that there are differing constraints here on the national data protection authorities to the extent that they could strategically go after the bigger players, because that would then change the landscape as a whole. Another way in which we could think about this is maybe in terms of how we interpret the concept of data controller. And so here I would say that the trend from the case law of the European Court of Justice is almost going in the opposite direction to imposing kind of strategic responsibility. Instead, if you look at recent case law like Facebook fan pages and Fashion ID, you see that rather than kind of focusing on strategic actors, we're instead saying that anybody who is involved in the personal data processing chain could be responsible as a joint controller for personal data processing responsibilities. So in that sense, responsibility is being fragmented rather than imposed in a kind of a centralized way. So I think that we need to consider the longer term implications of that interpretation of the concept of data controller, because it is one interpretation amongst others that would be feasible. But I guess what I'm most interested in are ways beyond the GDPR framework where we might think about imposing responsibility on dominant digital actors. And so here, the obvious legal tool would be competition law. And so over the past few years in Europe, we've had significant developments in terms of competition authorities trying to use the competition toolkit in order to take legal actions against dominant firms. With, I think, the most high-profile example of this being the action taken by the German Bundeskartellamt, the competition authority there, against Facebook, alleging that Facebook had abused its position of market power by extracting unlawful consent from users of the Facebook platform. And I think that's useful to think of as an example because the Bundeskartellamt issued its decision. That decision was appealed before a court, and a court has now issued an injunction against the decision of the German Competition Authority, essentially staying its findings. And why I think that's useful for us to consider here is that the reasoning of the court in that case begs a lot of questions for data protection lawyers. So in particular, I think if you looked at the reasoning of the court, there are two things that are potentially alarming from a data protection perspective. So one of them is that the court insisted that there had to be a tangible connection between the position of strategic market power and the abuse of consent. So the query here was, would Facebook in this instance have been able to extract consent in this way if it were not dominant? So this leads to the argument that, well, this is just the way everybody extracts consent in the digital environment, and so it's not Facebook's dominance that allows it to do this, this is just the rules of the game. Of course, this ignores the fact that the reason why we don't have a proper market and kind of market competition around consent is because we could already say that the market is broken in some senses, and that it's impossible for alternatives to emerge when some companies have such a stranglehold over the digital environment. So that's maybe one thing to think about. A second thing was the reasoning around consent that was used before the court, or used by the court, was quite poor, insofar as the court simply stated multiple times that the fact that 50 million German users did not, or German citizens did not use Facebook, was proof that consent in this context was freely given and could in no way be coerced. So it ignored a lot of the behavioral economic evidence that we have about network effects, so about the importance of Facebook as a professional and personal platform for individuals, and the fact that the more users that are on the platform, the more users that will need or want to use the platform. So it looked at consent in a way maybe the consent was being looked at 2 decades ago in data protection law. And so in this case, you can see that the combination of data protection and competition law here, while potentially very useful, in fact repeats and consolidates some of the failed approaches we have had in data protection law. So I think we need to start to look at examples like this and think of policy prescriptions as a result. So one solution here would have been, for instance, for the court to have taken more evidence from data protection authorities about what proper consent would be, but also to have looked at this through kind of slightly novel angles. So, for instance, to looked at this practice as one of excessive data collection, in the same way that we might have excessive pricing as a competitive harm. And so what I'm trying to get at here is that I think in thinking about the next 5 to 10 years, we will of course need to think about how we can strategically enforce the GDPR, but also think about the political economy around the GDPR and about how other areas of law, competition law, consumer protection law, increasingly environmental law and other areas are kind of impacting on the overall patterns of personal data processing we see. And if I could maybe make one last point, it's that in Europe at least there's a lot of discussion around, and also I guess in the context of the US presidential elections, about whether or not it would be appropriate to look at certain platforms as essential facilities or as kind of public utilities, so to impose public utility style regulation on those platforms. With the logic there being that if we can't focus data protection law primarily on these platforms, and if competition law is kind of looking at different types of harms, primarily economic harms, then we might need to kind of fill that gap by creating a legislative framework that imposes responsibilities only on dominant companies and that kind of goes beyond data processing obligations as such, so that looks at this more in the round. And this, I think, was a point that was touched upon this morning in a fantastic panel in this room where this a vision for a shared digital Europe was presented, talking about maybe not prohibitions on what we want to see done with data, but rather how could we proactively shape the digital environment, not around a digital single market, but around a kind of societal vision of the market that would look at this, again, a lot more holistically.
Thank you. You touched a very different and challenging topic, and I think one of them that wasn't mainly in your introduction is about data controller. And I remember an article written by Paul Daher on the distinction of data controller and data processor. And the problem again is that the existing categories that we have do not fit well with the real application of this category when we use the existing technologies. And this is something that we can discuss further, but I think that this induces also to have a sort of, if you want, a regulatory and political perspective, because the GDPR, we should remember from a legal perspective that it is a regulation, as a regulation is necessary based on the directive. And the directive is 1995. It means at the beginning of the 90s in terms of structure. And of course, that scheme so clear with the controller, a processor, with roles that were very specific, it doesn't work in a system in which the role, starting from the working context, are very changing in terms of overlapping and interconnection and so on. And this, I think, is part of the post-GDPR order, not only to address new challenges, as you mentioned, and we discussed these challenges about competition, but also to reconsider the theoretical framework for a certain instance, because the theoretical framework, of course, should be updated, considering new challenges. And in this sense, I think that we can continue our discussion, focusing on another point that is very important in data protection, more in general in the data use, that is about the potential harm. And I think that Amba will touch two aspects that are related to my last comment. So the categories, because you want to address the distinction between personal and non-personal use, personal and personal data, that for me is a quite sort of mystery, because it's very difficult to define what is personal, what is non-personal data. And then you want to discuss about harm, and harm also in terms of theoretical structure, and also in terms of distinction between US and the European approach is a very important point. And so I'm happy to have you, and the floor is yours.
Thanks, Alessandro. Just as introduction, we did this in the beginning, but my name is Amba. I lead global policy at the AI Now Institute at NYU. I just want to go back again to Julie Cohen's the discussion around her book yesterday, because I remember one thing that stayed with me was this comment about, the law creates categories, that's what it does, but in calcifying those categories, and that's something that happens over time, the law is not just reacting to its environment, it is often constructing it. I think what Orla said kind of takes that home as well. So I'm going to talk a little bit about recent policy interventions, both at the European Commission level as well as from the Indian government, both of which turn or are focused on the concept of non-personal data. Non-personal data is obviously defined in relation to and as exclusive to the concept of personal data as it is defined in the GDPR. So to start with, the European kind of in its digital single market vision, the Commission put out something called the Data Economy Initiative, which was aimed at, the stated goal was to improve unfettered access to non-personal data. And the kind of broad political goal for this was to increase the competitiveness of companies within the European regional economy. So a 2017 communication actually notes that what they're trying to encourage is that companies that have access to non-personal data sets kind of share those downstream, particularly with the SMEs, as one way in which to increase the competitiveness of European companies in the AI space. And so then we switch gears to the Indian government's intervention, which is from 2019, and reads less like a technical policy document and more like a political manifesto. It actually came out just a few weeks before the general election. And if you read it, it basically argues that Indian companies should have first dibs on access to Indian people's data. The paper is titled India's Data for India's Development, and it argues for mandatory data access. It argues, because it's still in draft stage, mandatory data access to data sets that are held by Silicon Valley, kind of with the broader argument that those data sets are almost an ill-gotten gain through a combination of first mover advantage and network effects. Interestingly, the latest personal data protection bill, which was tabled in the Indian Parliament not too long ago, actually has a provision in there which says all of this applies to personal data, but nothing in this act will prevent the central government from mandating access to non-personal data. So there are obviously many differences in scope between the European Commission's Data Economy Initiative and what's happening in India, but three similarities that I think are useful for us to meditate on. The first is that if you read through these documents, the overlying assumption and premise is that we're working in the realm of innovation policy, and this is about non-personal data, so there are no fetters or no constraints that come in from data protection law. So that's kind of taken as given. The second is interesting. It's kind of in the definition of non-personal data, outside of saying it's everything that isn't personal data, in the European document, the term used is machine-generated anonymous data. The Indian document uses the term community data. But what's really, I think, interesting is that the paradigmatic examples in both these documents are data related to transportation, data related to soil, seeds, the climate, and that kind of environmental data. And then finally, because these are the animating examples, it's sort of as a given that data-driven governance, when it has to do with these categories of data, is inherently good, and any kind of obvious concerns of individual or societal harm don't even come into the picture, because we're talking about, data governance and trying to make our cities work better and our farms more productive. So if it isn't obvious by now, I find this whole understanding of non-personal data as a zone that is free from both legal and ethical implications deeply problematic for a couple of reasons, which I'm going to go through fairly quickly. The first is, of course, the GDPR can of worms definition between personal data and non-personal data is very, very far from stable. I'm not the expert on this. There have been several papers that have now, I think, quite conclusively debunked, particularly this understanding of non-personal equals irreversibly anonymous, and shown how those categories break down. So already you're building on top of a very unstable foundation. But let's go back to those paradigmatic examples of the climate data and the transportation data, and remember that what these narratives obscure is the fact that these applications, usually machine learning powered examples that are given, they kind of ignore the political projects that are driving these as well. So whether it's the so-called smart city or it's algorithmic farming, I think what we forget is that these machine learning systems are not only kind of perceiving, but simultaneously adapting and controlling their environment. So there's a lot of interesting work that's being done now on the way. So Theodora Dreyer, my colleague at AI Now, works on how algorithmic methods of seed control are actually impacting farmer communities and indigenous communities. Nadia Purtova has an excellent paper which looks at a smart city system in Eindhoven that is collecting weather data, but it's used Eventually, it's used as part of a multimodal system to identify deviant behavior. There's my colleague in India, David Joshi, has talked about how this idea of taking private data sets, even let's imagine that the Indian government is able to do that, and then governing based on that might be deeply flawed. It might reify a lot of the biases and the context within which that data was taken. So I'll conclude with kind of two broad lessons as we move to answering this or thinking about this, imagining a post-GDPR order. The first is obviously that it is crucial that we do not reify this binary between personal and non-personal, particularly that we acknowledge that non-personal data certainly has political effects, and to that extent, it also has personal effects. There's, especially in the context of algorithmic accountability bills, and we're seeing this in the bill that lawmakers in the US have proposed, the threshold isn't personal data. It is, in fact, whether the decision impacts the individual or impacts the community, particular communities in disproportionate ways. So I think that's an important learning. And then in a slightly different gear, since just speaking back to the Indian political context, I'll just say that I think it's important to also keep reminding ourselves that discussions about data protection and data governance are going to be a battlefield for both industrial policy and developmental policy. So as anxieties about how different countries are going to compete with Silicon Valley in the AI economy just become more and more heightened, I think we cannot shy away from acknowledging those developmental imperatives. But at the same time, I guess what I've tried to highlight or tried to argue is that we need to ensure that rights protections as well as community participation are at the core and not at the periphery of these kind of innovation agendas. Thank you.
Thank you. Thank you for this sort of comparative analysis between this different system, and I think that is useful. Moreover, Indian is an interesting laboratory, because also in the first proposal of the Indian data protection law, that was very interesting because was very focus on outsourcing services. So it's interesting how similar legislation concerning data are used for different purposes. So if you read that version, it was, I think, in 2012, more or less, the wording was the wording of the European Union for a large extent, but the purpose was not exactly the same purpose. So it's interesting, and we see also in other cases this copy and paste from the European Union standard with different or slightly different purpose. And to conclude this presentation, I would like to further investigate about the future of the Ada Lovelace initiative with regard to this post-GDPR order and this working activity that you want to carry out in the next few months. Thank you.
Thank you, Alessandro, and thank you all for being here. Ada Lovelace Institute will be new to many of you because we are new. More broadly, we were set up only last year by a number of British institutions such as the Royal Society, the Alan Turing Institute, the British Academy, the Royal Statistical Society, and a number of others, trying to respond to this emerging field of the ethics of data and AI regulation and policy and technology. And so we're an independent think tank based in London, and we're focusing on bringing research to really complex issues of technology, policy and regulation. We start from the perspective, as Ravi and Orla really importantly emphasized, that the GDPR is a really fundamental building block of data rights and a really important leaping off point to think about how we should be ensuring that data is used in the public benefit and in the public interest. But we also feel as an organisation that the GDPR is doing a lot of heavy lifting, given its origin as the directive and the kind of long history of regulation that precede it, that isn't really fit for purpose in terms of where we're going in a data-driven economy and in an AI-driven future. And so as a think tank, our job is to think and to look forward, and we're asking in 20, 30 years' time, where should we be heading in terms of regulation, in terms of practices, to ensure that data and AI really do work for people in society, that we have rights and those are protected, and that we have practices that are really consistent with those rights. So our starting point is, first of all, that this is a long-term conversation that we want to start provoking now, and that this is not about undoing what is there in terms of the GDPR, but rather trying to understand what other forms of regulation, what other legal frameworks are necessary to build on top of the protections there, so that we can really, A, truly protect individuals' rights, and B, make sure that we are realizing and protecting the real social value of data. We think that the current framework lacks or struggles to reconcile a number of competing concepts. So things like, and these are threads that have come through others' presentations, consent and its insufficiency to really be applied in a protective manner given things like the dominant monopolistic control of markets. Things like whether data portability is realistically a right or a protection in the context of the lack of competition in markets. Whether the framing around individual rights is really sufficient to understand how algorithms in particular view individuals as collectives, part of collectives, and there can be collective harms that aren't easily reconcilable back to individual rights. Our distinctions around personal and non-personal data, as Amba really strongly argued, sufficient anymore. And equally our understandings of sensitive data and special categories of data really reflective of how those data are being used. I think biometrics is a key example of that. And then finally, does framing conversations around data really appreciate the economic and political power of data? And again, is data protection as a kind of technical area of legal regulation doing a lot of heavy lifting to try to reconcile really complex issues of political economy? So we're trying to start to stimulate some of that discussion again without rolling back protections but really trying to understand where should we be going in the future. And so we've embarked on a new program of work called Rethinking Data, and that has 3 component parts. It's about narratives, practices, and regulation. Today we've been talking about regulation. And so some of the questions that we're asking as an institute and as part of our research program are, what are the gaps in the existing regulation? How might other legal instruments help us fill those gaps? How do we enable a robust data rights framework within existing areas of law? And how can we kind of reconcile and strengthen both individual protection but also realize the social value of data, and how can we, what types of concepts such as the commons might help us think through that in a forward-looking way. As I said, we're pairing this with work around data narratives. We feel that the public narratives and the way we speak about data itself constructs how we think about regulation, and we're very interested to think about how to break out of existing tropes and move beyond concepts of data as the new oil and others, and try to think about how else can we better capture the true value of data in our societies. And also, how can we think about practices such as stewardship and trusts and others that might help us move this conversation along. We are under no illusions about this being a very long-term endeavour, so we've established a working group that will help us, who will deliberate in an independent way on some of these questions. It'll be co-chaired by Professor Diane Coyle and Paul Nemitz, and it will include an interdisciplinary group of experts from across law, society, technology, the humanities, and including our distinguished panelists here as well, and be trying to grapple with some of these questions over a 2-year period beginning in May this year. And we have kind of laid out the provocative groundwork for what we hope might inform that conversation, but you can see there the kind of very eminent experts we have as part of that working group will define their own agenda and then answer the questions that they set out. Those are the remaining members of the working group. we acknowledge completely that we're a new organisation. We're coming into a space with a lot of historical background and tradition, with a great amount of expertise, and we're absolutely not trying to reinvent wheels or ask questions that have been answered before. We have published a small prospectus that hopefully some of you will find on your chairs, and at the back we map out, as we see, all the really integral organisations and players that have been involved in this conversation to date and whose work we'll be really trying to build upon. And we're really opening our doors and our email inboxes to you all, to those who'd like to be involved in this conversation, including those at the table. But we hope that this can be something that we start to provoke now. And I hope in the discussion we can start to bring out some of your ideas. And we'll be here going forward to continue this debate over the coming years. As I said, I think we see this as a conversation that will take us to the middle of the century. Just as there was 20 years between the directive and the regulation, we think this conversation is informing regulatory processes that will take place in 15, 20 years' time.
Thank you, Carly. And I think that we have touched different kind of issues, and I would like to have your feedback if you have any question about the project or about the question that have been raised by my colleagues during the panel. And I think that we have more or less 20 minutes, consider that there is the closing ceremony, 20 minutes for this debate. So please, if you have any question, there's a micro. Okay, one question. I am privacy oriented, so I don't ask you to reveal your identity and affiliation. I think it's not a relevant detail. The question is the point.
Okay. So I have, thank you very much for your presentations. I enjoyed them very much. On the substantive side of our discussion, I think it's very interesting to see where your thinking goes. I believe that the essential question at the start still has to be, what are we actually talking about? What are we protecting? Or what is data protection about? The definition in the GDPR is relatively vague, as I'm certain you're all aware of. And at the same time, especially when we go forward thinking, there are still other concepts out there, such as informational self-determination, and many others like group privacy and so on. So often difficult to operationalize them. But I think at this point in time with GDPR where it is right now, we're in a lucky situation that it has captured the discussion, but I'm afraid that when it will be too difficult to enforce, then there might also be sort of a lack of focus. And I think it's especially for probably this community which is here to have those deep substantive discussions going forward and to keep those other kind of concepts in mind, to not lose that focus. And on the enforcement side, I'm wondering whether we are getting a little bit too confident with the human rights narrative. Traditionally, this space has not been a human rights discussion. It has become very much in the last decades, and I'm going to reveal that I'm arguing a little bit against my own profession in that sense. But I'm really wondering, or what I would like to ask you and get your perspectives on is, maybe we should be more open and more comfortable to explore also other ways, not framing it necessarily in the human rights perspective, because human rights is great to have those substantive discussions, but it's not very good in actually helping with enforcement. We often see, yeah, we can argue about that, but it's difficult to go to a high court which then actually changes something for the people who are affected at the end of the day. And I think that's also a little bit, it takes some time. And yeah, so thank you.
Okay, if there are any other questions, please. And then we try to collect the question.
Hello, my name is Walter van Wolfs. I'm with as Remember Vrijschrift, and I'm wondering why this panel is lumping together all data issues together with data protection issues. There are also clearly competition issues there. There's some other social justice issues being mentioned there in the case of the C data. I think that for the clarity of the conversation, this is actually deeply unhelpful. So I'm wondering what the motivation for this was.
I just wanted to follow up on what was said at the end about sort of changing narratives, because one of the questions that I think about in the shifting landscape of increasing awareness of how data is used, some of the people that we're leaving behind in terms of technical literacy or ability to understand how their information might be capitalized on and their ability to exercise their rights. So kind of as we push for new narratives and try to understand how we bring maybe more people into the conversation, where do we see that trend and what might be able to do to get more representation into the direction that this is taking?
Thanks a lot. I'm Thomas Strines at NYU Law School. I kind of following up on your question by taking the opposite stance and maybe pointing out how there are different ways of slicing this. So certainly confirmation bias at play, but I really liked that this panel put together these different issues, because I think there's a lot to explore in terms of what is captured by the data protection framing, what is not captured by it, and how does the data protection framing come into tension with other societal objectives that we might want to achieve. And that's something that we also think about it at NYU, and I look forward to engaging more with the panelists on these questions. But there's a question, where do you draw the line then, and what is your normative commitment in the end? And it was already tabled whether human rights law and international law could be such a normative baseline or not, and I heard like different varieties of normative agendas in the remarks by the panelists. But the question I wanted to ask was about a different type of line drawing. So if it's right to rethink the way law interacts with data and the ways in which digitalization transforms our environments, as Amba points out, there's a question there whether we can sustain the idea that there's a uniform way of addressing these questions, giving the variety between cultures, societies, political systems, and so forth. And that's a challenge that internet governance has faced for a long time. So I was curious what the panelists were thinking about that challenge, particularly here in Brussels, which has evolved into some kind of global data protection regulator. And it seems a bit unlikely that the kind of other types of regulatory interventions that we might need globally would necessarily need to come from here.
There's a last question. Yeah. Also in the last row.
I'm Stuart Dresner from Privacy Laws and Business. Amba referred to the big tech companies having big data sets and their ill-gotten gains. As we're doing blue sky thinking here and extending into the future, would anyone think that we should be applying the law of theft to the acquisition of personal data by the big tech companies, without naming any names, of course?
And the last question, the last row, please.
Thank you. Well, I follow Alessandro's invitation not to say my name, but full disclosure, I was involved in the development of the GDPR at some point in time. It's more like a comment, like some of the other questions, and of course I share many of the questions, like Walter's thoughts and some others. I have a lot of confidence to some of the members of the board that they will be able to free the group from possibly misinformed starting presumptions. But I would really recommend that some of the assertions made in the presentation and in the context should be reviewed thoroughly by the groups. Like some of the narratives, the future will be data-driven, we will depend on algorithmic development. We had an ethics panel the other day where exactly these assertions were very much questioned by the researchers, and I think it would be necessary for this group to succeed in order to become more than a re-initiation of the World Economic Forum's failed data monetization or valuation initiative 5 years ago. Thank you. I'm sorry that I cannot follow your discussion, but that's something happening in the other place, which you know that it's very important for my professional context. Thank you.
Thank you. And about the last comment, I want to clarify that, as already mentioned, the Lovelace Institute has its own research agenda and its own approach to this topic, and the board will be free to adopt its own approach that is not necessarily in line with the institution. And this is something that we have already agreed in order to maintain the independence of this kind of board. And due to the fact that, of course, we have the final ceremony, I ask you not to give an answer to all the challenging questions, but to select your most favorite question and give an answer to this one in a short time, if you can. Thank you. Please.
I can start. Do I have to choose my most favourite, or can I choose my least favourite?
It's okay. It's a
so there's a question about a lack of focus on potential other issues when thinking about enforcement and whether we're too confident in human rights from the anonymous source. So I just, from a practitioner's perspective, when a client comes to you, they don't really know about data protection. They don't know about all the laws that have affected their circumstance. So your job is to think of all remedies that may be applicable. It's not just, oh, well, you've got this issue, so it's just data protection. We will throw everything that will possibly stick to try to get a remedy for a client. And the reason that the human rights framework is so important for that is that it's a base level for the first point, that you can't barter yourself out of it. It's not about money. And secondly, because it's not about money, because it's about rights, you can be clever with orders from a court. You can ask a court to get a processor to do something, a controller to do something that's not about money. Take something down, do something else with the data, or give it back. And that's really powerful, and that only really works when you take it as a rights-based framework. Oh, also, on theft, theft requires dishonesty is a question about honesty of what the companies are doing.
Well, maybe if I address the question about whether or not we are or should lump all of these issues together. And I think here you could divide people into two camps. So on the one hand, we could say, well, we have data protection regulators, we have competition regulators, we have consumer protection regulators. Each has their own competence, and we shouldn't try and blur the boundaries in any way here. And they should operate in their silos, and that would lead to a kind of an institutional clarity. On the other hand, I think that there are legal reasons why we should be looking at this holistically, and this goes to another point, which is that all institutions, agencies, bodies of the European Union are bound to respect the European Charter of Fundamental Rights. So that's kind of, I guess, the end game. So respect for the Charter of Fundamental Rights and the promotion of kind of a social market economy. And here I think the risk of looking at this in a very siloed way is that you miss the bigger picture, and that you get internal inconsistencies between these policies. And you can start to see lots of examples of that emerge. So on the one hand, you might have in a competition context, companies arguing that data is not necessary in order to compete on the market. So it's not the quantity or the quality or the variety of data we have that is significant, it's what we do with it. Whereas, data is kind of irrelevant to compete. Whereas on the other hand, for data protection purposes, they would say, well, we're not collecting more data than is necessary, so we're perfectly compliant with data minimization because all of these data are necessary for our purposes. So these are kind of mutually inconsistent claims going before two different regulators. And so I think in order to kind of get a handle on the overall data processing practices of companies, we need to be looking at these different claims before these authorities and considering the business models as a whole. You know, another example would just be, and I think this goes to Stuart's point about why not theft. Well, if the data is what could be illegally acquired or what people want access to, well, we all know that competition law might mandate access to data, which would then cause serious difficulties for data protection and privacy rights. And so again, here you could see how those two policies might pull in mutually incompatible directions, even though they are both EU policies, both subject to the European Charter. So I do actually think that this isn't in fact throwing things together, it's trying to ensure coherence across policies looking at these business models.
Thank you. Please.
Yeah, so I just, to the theft question, just to take your metaphor forward a little, I think the interesting question then becomes, who is the property going to be restored to, even if we accept that it was theft? And it's so interesting that in India, what we're seeing as a response to that is that it is the state or the nation from whom this data has been stolen, and therefore the argument of the state becomes a kind of right of eminent domain over the data of its citizens and of its people. And that raises really important questions for whether we're just going to reify exploitative data practices just with a domestic rather than a foreign stealer, if that's the right word. Anyway, and then I think to the question that you had at the back, sir, about algorithmic development and taking that for granted, I hope I didn't give you the impression that that is the camp that I'm sitting in. Much the opposite. And I think there I want to say, and this answers Thomas's question a little bit as well, which is that I have a lot of anxiety around this one regulation to rule them all, especially when it comes to AI, because what you're actually seeing like what is required right now and what is developing, I think, in many countries is a strong politics of refusal, which is located in particular contexts and coming from particular communities that are being hurt themselves. So I think we should, that any regulatory interventions, I don't know if sector specific is the right word, but should definitely try and emulate that bottom up and contextual approach as far as possible. Yeah.
I'll speak to the narratives question, but I just wanted to endorse what Orla said about the kind of reason why we believe these kind of potentially diverse areas of law need to be considered together. I think the legitimate interest as a legal basis for data processing is a really good illustration of why you need to think about these issues beyond just data protection. The legitimate interests kind of legal sanction is built upon this balancing act between the legitimate interests of the company and the individual's fundamental rights and freedoms. And I just don't think that we can think about how to balance those two things without understanding the value, the monetary value of data, the business model issues, the social value of the data, its potential to be used in the public good, as well as the individual's own personal rights. And it may be trying to overload the conversation to try to feature all of those in the same legal framework, I suppose, but it seems to me that we'll never, by staying in a narrow conceptual of data protection, we won't be able to truly grasp things like that. On the narratives question, in terms of the methodology about bringing alternative narratives into the conversation and different viewpoints, so as an organization, we're modeling some forms of public deliberation and public engagement that we're hoping might be able to bring new ways of thinking about these issues. And I've got two examples of how we're doing that. The first is we've convened a citizens' jury on the question of what a fair data partnership looks like between health authorities and private sector entities. And this is particularly in the UK, where many of you will have seen there's been quite contentious questions of when the NHS should hand its data over to DeepMind, for example. And we think that bringing the public into a conversation of what does fair look like when you're talking about health data is one way to inform that discussion. The other is we're about to convene a citizens jury or citizens assembly type deliberative process on the question of biometrics, again speaking to this public discourse around facial recognition. How should we think about what public trust and public legitimacy looks like for biometrics technologies? And the way to do that, I think, is really about building up an informed conversation with the public. So it's not about opinion polls and focus groups. It's about sitting down with people over a long period of time, giving them information, helping them to realize all the different vested interests and facets of a conversation, and then asking them to deliberate. So we think that type of methodology, that is public deliberation and engagement that's on an informed basis, could help to address some of these narratives questions.
And thank you. I want to conclude pointing out also on the basis of your last comments that the public engagement is very important. And the public engagement is not necessarily the best way to address some issues. And we have also political recent experience in this sense. And I think that public engagement is a key role, but when we talk about data protection is historically based in Europe on human rights and recognized as a fundamental rights. And I don't see, personally, any alternative narrative in this context in our framework, also because alternative narratives are not so positive in order to safeguard the existing rights of data subject, moreover in a context in which they are very challenged by the new application. And if I may, a comment about legitimate interest. Of course, more or less, you all have a background in data protection, and you know that legitimate interest has some very, very specific limitation based on the balancing of interest and the potential impact on the individuals and its rights. So I think that it's very important to create new narratives, if you want. But one thing is the narratives, one thing is the legal framework and the human rights that in Europe are considered as a main reference for this entire topic. And I think that is also the main message of this conference, and I am convinced that we also repeated in the closing ceremony that now we could attend. Thank you for participating.